Hey, everybody. It's Tony from Vegas next to our legal scholar, Alan Thayer from Eugene behind enemy lines. And this is part two of our conversation from last week when we found out that we are going to have the hearing on the temporary injunction. And today, big haps in the courtroom. Oregon State and Washington State were granted their request for a temporary injunction. Alan, what have you learned?
Well, what did I predict last Friday when we first found out about this?
That's right. You said that you felt that there would be representatives, possibly from the other schools, in the back of the courtroom. You
Well,
felt that.
most importantly, I said that the TRO would be granted.
Yes, this is true. And that in about 2 weeks, there'd be a follow up.
Yeah, 2 or 3 weeks.
Uh-huh.
And that's exactly what happened. The Oregon State argued prevail on the merits. We've got notice requirements. We satisfied the notice. Irreparable harm. We want to preserve the status quo. That was the Oregon State argument. A couple of things about and I say Oregon State's argument but WSU's in here too.
Right.
But whereas it has appeared up to this point that WSU has been taking the laboring oar on these issues.
I see.
That wasn't the case in the hearings. The attorney that led the charge for the plaintiffs for Oregon State and Washington State was Oregon State's attorney. And he did a good job. Very methodical, very thorough, kind of just hit the right points. And as I had also predicted, he referred to a preliminary injunction hearing down the road.
Now I heard, excuse me, I heard that he did very, very well in comparison to the Pac-12 attorney. Didn't sound like he was too prepared, or really his arguments were pretty weak on their face.
Well, I think part of it was their method of delivery. The Oregon State attorney read from prepared comments, and he read the entire time. And where the camera was positioned on the video that was shared online on YouTube, where the camera was positioned, you could just watch him read it. Whereas the other guy was speaking off the cuff, I guess, but he was a little less organized, a little more methodical, and he did not address the issues that the Oregon State attorney addressed. And this is really common in situations like this, where both sides seem to be arguing in different directions. And
all right,
going on. Another thing we saw from the other attorney is that people try to justify their decisions even when they don't want you to know the real reason for the decision, if that makes sense.
It does.
So, I'm not coming up with a good example at the moment, but you know that if you say the real reasons for wanting something, it makes you look bad. So you come up with these other justifications.
Correct. Absolutely.
And I think there was a lot of that going on. They making the argument that the commissioner was in a terrible position, stuck between these two feuding bodies. And he's got 10 universities on one side and 2 on the other. And it just puts him in a terrible position. He did argue the notice issue a little bit. And he tried to claim that not allowing USC and UCLA to vote and not allowing Colorado to vote, that was different than it is today, because today there's no longer a media rights contract at issue. And I think that is something you're going to hear in the future. Now, what does that have to do with anything? I'm not really sure. The bylaws are what the bylaws are. But when we get to the preliminary injunction, I would expect more to be made of that in the future. You don't really have a conference without a media rights deal, for example.
Well, interesting, because now you mentioned the bylaws. It doesn't, I mean, I don't think that particular clause exists that specifically relates the lack or the acquisition of a media rights deal as fundamental to the existence of the conference. That seems absurd on its face.
Well, it will be an evidentiary argument that will come up at the preliminary injunction hearing. And they probably are going to try to make a big deal. Okay, what constitutes a conference? With these 10 universities gone, is there a conference? Is there anything left for Oregon State and Washington State to preserve? And that will be if we get to that point. The judge granted the motion, but he made a couple changes to Oregon State's requested form of TRO. And one of the things, and listen, this judge, I liked the judge. There is probably no doubt this is the biggest case in his career. And he was an older judge. In Whitman County, there's 47,000 people in Whitman County. But the courthouse is in Colfax, Washington. They have fewer than 3,000 people in the entire town.
Which means the judge probably knows everybody, including everybody down at the local diner where he has lunch every single day.
He does. I mean, I think they picked the right venue. The other change he made, though, Washington's or the conference's attorney made a big deal. Said, "Oh, we have to have this meeting because we need to know how to move forward and just keep the lights on and run everything. And we need this employee retention agreement. We have 196 employees, and we're going to lose employees, so we have to have this." But then he slipped up. He also made comment at one point we need to talk about dissolving the conference. He did say that in there.
Oh my.
And it's talking about, well, we just need to get all the parties together to talk. And the judge goes, well, yeah, I can tell you how that vote's going to go. That's going to go 10-2.
That's classic. Now, I heard, as a side note, maybe this is something you heard as well, that came out, was that the 10 schools want the conference to pay for their exit fees.
Yes.
How?
Well, there was a reference to that by Oregon State. And they don't have exit fees leaving the Pac-12. And so I'm not sure what fees they're talking about. They actually talked about transition cost. And supposedly that was in a budget that was given to Oregon State and Washington State. That was in there. There was also some reference to a bylaws amendment to be considered by these folks. Presumably the bylaws amendment would take out this notice provision that once you give notice, you don't get to vote.
Oh, well, of course, that makes perfect sense.
So what the judge asked everyone to do is well, before we get to that, there was also a big issue about were necessary parties before the court.
Okay.
And that is an issue in certain cases, and you have to have everybody before the court. And here the conference is trying to say, well, judge, you can't hear this because Washington State and Oregon State doesn't have everybody before the court. Well, there might be some issues as to jurisdiction, issues as to sovereign immunity, because most of these are state schools and you can't sue the state except for when the state's agreed. In Oregon, it's called the Oregon Tort Claims Act. Then you have to follow certain steps before you can sue. And this just makes things really complicated. Oregon State responded to that in two ways. One is it was the commissioner who was proposing to take this act. So therefore, it's the commissioner who we seek to enjoin. And two, if other schools want to intervene, we will not object. Now, by intervening, they're voluntarily submitting to the jurisdiction of the court. And so if there is some sort of an Arizona Tort Claims Act, which you have to give 90 days notice before you can sue them, they will be waiving that by virtue of requesting to intervene.
And if we recall, intervene was a fancy way of saying reply, right? Respond to the accusations.
Yeah, in this case, it'd be to join the lawsuit.
Okay.
To join the lawsuit. Now, the judge has said, hey, we're going to be doing a preliminary injunction hearing. We're going to be doing expedited discovery, and we talked a little bit about discovery the other day. You guys get together and get me some dates, and we will move this as quickly on our docket as we can. Basically, all but told them we'll schedule it whenever you want to schedule it.
Nice.
You would not get that if you were bringing the case in San Francisco, I can assure you.
100%. Now, so you're thinking it's going to be about a 2 to 3 week process based on our conversation last time, and then earlier, just a few moments ago. Now, I've heard a lot of things about the discovery process, and I'm assuming that means that there's emails between people, either from schools to George K. and back and forth and so forth, that all falls under the discovery process, does it not?
It does. Now, you just referred to George K., and I don't know how to pronounce his name, and I can try to butcher it. But on Saturday at the game, when people were asking me questions, I decided just to refer to him as George Clinker, or Clinker for short. So that seems to work. Yes, I don't know if people really want to allow this kind of discovery to go forward.
Exactly.
Lawsuits are about leverage. Lawsuits are about trying to get people to deal with issues that they would prefer not to deal with. And lawsuits are about equalizing the expectations of the parties. So a lawsuit is a transaction like any other transaction.
Okay.
And if you wanted to sell your house to me and you thought your house that, Las Vegas is a growing area and it doesn't make any difference what I pay for my house, I think my house is worth $7 million.
Right.
And I can say, well, that's nice, but I don't know. That looks like $165,000 house in I don't know, pick a place. I don't want to insult anyone here. I had a couple names in mind, but I decided not to mention those communities. And we aren't going to reach a deal on your house unless we equalize the expectations of the parties. And that's the case with a lawsuit as well. Today was important because Oregon State remains in the game. And the status quo is going to be preserved. And Oregon State has some leverage. I think there's some other things that Oregon State can do to get leverage. And I don't think you and I talked about it before, but I have talked with others and I've made some comments on Beavers Behind Enemy Lines that there very well may be some antitrust issues here. And then now the parties for an antitrust case would be certainly the conference, certainly the treacherous 10, but also the Big Ten, the Big 12.
Yes. It would be the conferences as well as the television networks, right? It's going to be
ACC,
Fox and ESPN.
Fox and ESPN. And sports have been skirting around the antitrust laws since the creation of the antitrust laws. And a specific exemption was made, I think, for the NFL, for one of the sports, but there hasn't been an exemption for any other sport. and there isn't an exemption for college sports. Uh, and everyone's just kind of looked the other way. Oregon State and Washington State could press the issue. And if there were a set of facts for pressing the issue, I think these would be a very, very good set of facts.
Oh my, yeah.
Fox isn't going to want it. ESPN's not going to want it. The conferences aren't going to want it. I think the SEC was smart by staying out of this round of realignment, by the way, even though arguably they're the ones who started it by nabbing Texas and Oklahoma.
Right.
But that threat could give Oregon State additional leverage, as could. So at the game on Saturday, I ran into a good friend of mine since our Oregon State days.
Right.
And Cynthia Anderson. And Cindy came up to me at the end of the game and told me that she was sitting next to an attorney who does Title IX cases. And he thinks that this is a Title IX case.
Interesting. Because it affects the women's sports.
No. So like you, I think of Title IX as affecting women's participation in sports. But according to him, Title IX is also about student athlete welfare.
Oh.
And how hard of an argument is it to make that shipping kids all across the United States so that Fox and ESPN can get their preferred games is interfering with student welfare, particularly in these days where the mental health of our student athletes has become a prime concern.
Yeah, well, that comment has been made multiple times by our president. I think she's done a very, very good job in her appearances lately, including on CNN recently, and she's just done a great job. I think including "We're ready to fight," I think is a wonderful comment, and just shows her dedication. I think that you make a very, very good point. I mean, they always say sunlight is the best disinfectant, but I don't think anybody wants. Those guys don't want anybody in there peeking and looking at their conversations, especially between from school to conference and conference by extension, conference to network and network to school. Okay, we'll make sure that you get this if you go to the Big 10 or you go to the Big 12 or whatever. I think this goes back to what you said the last week, where settlement is the big word, I think, is where it's really going to come down.
Well, here's what this kind of leverage can do. This kind of leverage could result in the Fox, ESPN, ACC, Big 10, and Big 12 saying, okay, we're going to have to find a home for Oregon State and Washington State. Let's offer them a deal. If that were to happen, here's what I would hope Oregon State and Washington State would do. I would hope they would say, we want the Big 10, and we want a full share. And if you don't give us a full share, we are continuing on this front.
Oh my God. So I think why not shoot the moon?
Yeah.
Know?
And so then wouldn't it be great? I mean, we're back with Oregon now and UW, and we get full shares and they get half shares.
Jesus, that would be poetic, would it not?
Yeah. And you start by saying you want a hell of a lot more than that, and then you come down to that. I don't know. I don't know what their strategy is, but here's what I do expect to see happen. I expect the conference to obfuscate and delay. They have been delaying for over a month, providing answers to simple questions.
Absolutely.
They have ignored media requests for asking the same questions. There will be a tight timeline before this preliminary injunction hearing, and I suspect they will do everything they can to stretch it out and delay.
And how long do you think they could actually get away with that before Oregon State and Washington State say back to the judge, look, we did due diligence, we offered whatever. We asked for this, that, and the other. They have not provided. They refuse to provide. Can we just go for a summary judgment? Can they do that?
No, here's what they do is they start by asking the judge to intervene and to issue an order saying you must produce this information by this time. And then if the information doesn't get produced, they ask for sanctions. And the judge, well, we'll give you one more time. And if it's still not produced by then the judge has a range of sanctions at his disposal, including just granting the relief requested. There's also the question that I really don't know if these schools voluntarily join the lawsuit. And
so in other words, if I may, if they don't, then there's no discovery allowed because they're not part of it.
No, there still could be discovery because
from them directly, though.
Absolutely.
Okay.
And in a lawsuit, there's oftentimes you have information that is possessed by non-parties, and there's a method to obtain that information, and it's called a subpoena.
Right.
And you can subpoena that information from them. I don't think they're going to want to release this stuff. I bet you are people writing things that are just very critical of Washington State and Oregon State.
Guaranteed.
I suspect that things are being said which would be a huge help in an antitrust case.
Oh my God. It.
There even could be some things that could be used as evidence in a Title IX case. I don't think these guys are going to want all this to come out.
Right. So, no, there's no way in heck they're going to want it to come out. I think you're absolutely right. Leverage is huge right now, especially from the discovery side of things. There's no way they want sunlight on this stuff. I'd like to propose another option as well. Potentially, versus joining the Big Ten or whatever, is I could see them really not wanting to go over there. I think there's a path to an easier path, if you will, of getting to the college football playoff by reconstituting the Pac-12. And if you have the same leverage of $50 million or whatever it is, and $70 million or whatever for Big Ten money, 30-some, 40-some million dollars for Big 12 money, then they could say, you know what? We want that money for a Pac-12, a reconstituted PAC, that you're going to go ahead and give us our TV deal, and we're going to have an excellent TV deal, and it's going to be somewhere in the 30 to 35, $40 million range. And that automatically is sitting there, no matter who comes into regardless of however many schools come in, this is what they're going to get, including us. So now you've got the opportunity to be able to throw $35, $40 million potentially at any school that comes in. Plus they can go out and still renegotiate the Apple deal for a streaming.
Well, just as long as we get 2x what the Ducks get without the travel, that would be fine with me.
See, now that to me is that's what makes that appealing. They keep it because Oregon State and Washington State have been very much, and rightly so, regionality, welfare of the athlete, et cetera, et cetera. And by saying, okay, we'll take your 50 million and go to the Big Ten, they come across as hypocritical.
Yep.
And so I really like the idea of them leveraging the networks into getting the kind of money that they would have, or more money, quite frankly, than they would have gotten if they had taken the $30 million deal from ESPN, 18 months ago or whatever it was. Plus they can get a streaming deal. I mean, to me, they could come out smelling like a rose, especially if our thoughts are correct about the discovery. Sorry, I was having as Monday, so trying to draw a word out there. The discovery and a lot of things not wanting to be brought out into the daylight.
George Clinker, I think, is being a little disingenuous because he keeps saying, I'm in a terrible spot. I'm in a terrible spot. I'm in a terrible spot. Well, if that's the case, why are you advocating for the people who aren't there?
Because he wants his golden parachute. That's what he wants.
What George should be doing is he should have argued, hey, Oregon State, or excuse me, Oregon, Washington, Stanford, Cal, everyone else, this is your fight. It's not mine. What do you do when you're in the middle? You don't pick sides. You don't
I guess, but
don't come to the court arguing. You come to the court that says, tell me what to do.
That's a very good point. But at the same time, he's supposed to be the commissioner of the conference, and the conference itself is really two teams now. After this year,
as I said at the beginning, the arguments he was making are not the real motivations. I mean, obviously, the treacherous 10 have wound him up and said, you go do our bidding for us.
Well, I'm going to go one further because I'm a little bit of a black helicopter conspiracy guy. I believe that they talked to him and guaranteed that his big fat golden parachute would be covered after the end of this season, and that he would be paid in full. And I think it was, last I heard, it was like $3.5 million in guaranteed post 2024. So he stands to put millions of dollars in his pocket if they can do this extension of, employees and whatever, and his little golden parachute is covered. So of course it's in his best interest to side with the people that have guaranteed him that he's going to get taken care of.
This is an opinion video, and any statements made by either Tony or I are mere opinions. I am a lawyer, but I'm not licensed to practice law in Oregon. I have not seen the actual bylaws. It's not for lack of trying. I've spent hours trying to find those bylaws. We've actually tried to sign up to be able to download documents from the court file. And it was odd. We got the response that those documents have been archived. So evidently there is some sort of confidentiality in place here at the moment.
Oh my goodness.
So anyway, we're making opinions based upon limited information. And in my instance, I guess with some understanding of the court process, but I'm not a Washington lawyer. So Tony may be a black helicopter guy. What we tell Tony is, just because you're paranoid, it doesn't mean they're not out to get you.
That's right. Doesn't mean they're not watching.
Right. It was a good day for Oregon State. The Oregon State attorney looked good. One other thing I noticed is that among the attorneys listed for Washington State is someone from the Attorney General's office, from the Washington State AG's office.
Interesting.
But there is no one from the Oregon Attorney General's office involved.
That doesn't surprise me.
No, it doesn't.
It really, really doesn't. The fact that there's been not a peep out of any legislator in the state of Oregon or anything that's come around is not surprising, but at the same time, very disappointing. So lots and lots that can happen over the next couple of weeks. I'll throw my prediction out. This never makes it to the preliminary injunction, or what do you call it?
No, you got it right. The preliminary injunction hearing.
I don't think it ever makes it there. I think that settlements abound, and I think that lo and behold, there'll be some things like you talked about and I talked about, that there'll be all of a sudden there'll be a reconstituted pack whatever with a nice fat TV deal waiting for everybody that comes in.
I would like that. I don't know if that happens, and here's why. The TV networks are trying to limit the universe of Power 5 universities. And this would, what you propose, as much as I would like to see that, what you propose would expand the number of Power 5 universities. Because as part of the settlement, you're also going to have to maintain your autonomy status and your college football playoff status. And that just goes in the entire opposite direction of what they were attempting to do.
I know, but boy, oh boy, I like the idea of the antitrust. And there's been a lot of people talking about that, quite frankly, outside of just our little universe here, that the collusion that had to have taken place between the conferences and the networks and the schools coming in had to know what was going on. I mean, there's a lot of moving parts on this thing, and a lot of behind the door, backdoor type of deals that were being made, and discussions that all of it wasn't just done via phone. The email is a killer. I mean, just a killer.
An antitrust case could blow up college sports in ways that we can't even anticipate, because I think the antitrust issues go so far and so deep as to everything that the NCAA and the conferences do. The question is restraint of trade. And there's a lot of that going on. That could be, well, you could write books about possible antitrust issues involving college sports. But where we are today, Oregon State had a good day. It was not unexpected. The fireworks, if they're going to come, will come at the preliminary injunction stage after expedited discovery, whether that happens or not, and then a briefing schedule and oral arguments, and we will see who is before the court.
I'm excited about what the next couple of weeks. It's nice to come out on top. Congratulations, Oregon State and Washington State working together as a team. 2 weeks from now, when we're when the Beavs are in Pullman, I think that's going to be a spectacle of positivity, if you will, and I think it's going to be just a wonderful, wonderful atmosphere. I'd love to see all the players get together on the field and wave to the crowd, and just a genuine show of unity. I think it would be pretty neat. Let's do this again, Alan, when even more stuff comes out. Sound like a plan?
Oh, I think we can. One other thing. So for any WSU fans who are watching this, if you were not at the Oregon State game against UC Davis, when they announced the Washington State-Wisconsin score, the crowd let out a roar, and it was a thunderous roar. The only thing that could have surpassed that is if Texas Tech had taken care of business and not turned the ball over in the final minute. If Texas Tech had beat the Ducks, I think they might have cheered a little louder. But WSU fans should be feeling the love from Oregon State fans.
Absolutely.
And I'm told that the vice versa is true.
It's very true, especially on Twitter, where I kind of cohabitate. So anyway, that's it. Thanks a lot, everybody. And we'll talk to you soon. Alan, always a pleasure.
Thanks, Tony.
Take care. Bye-bye.